So good evening, everyone. So everyone in the Cassese room of the Villa Moignet, but also everyone online. I'm Gloria Gaggioli. I'm the director of the Geneva Academy of International Humanitarian Law and Human Rights. And I'm leading a project which is called Counter-Terror Pro Legem, and which is based at the University of Geneva. I will have the pleasure to moderate this panel on the Swiss counterterrorism laws. Please be aware that we are able to get your questions for those following online through the chat. So we will first have a little introduction so that I present you the context. Then I will introduce you to our marvelous panel. And lastly, we will have a Q&A session. So for the context, as you know, for many years now, numerous European states have been taking far-reaching laws to prevent and combat terrorism and violent extremism. Some laws aim at creating terrorist offenses, such as the financing of terrorism or the criminalization of the participation in or support to terrorist organizations. So there we are in the criminal law realm. But in parallel, there is also a proliferation of administrative measures. We can also call them police measures that are ordered by the executive and that are of a non-criminal nature. Their objective is to prevent terrorism and radicalization. So for instance, you have the deprivation of citizenship, which is a kind of administrative measure that has been adopted by some states. We have the fact of prohibiting individuals to return to their country of residence. And you have also control orders, which aim at limiting the freedom of movement of some individuals. So for instance, in UK, in France, Germany, control orders have been adopted, such as night curfews, assigned residence, or the obligation to report. Now, Switzerland is now no exception to this tendency of adopting control orders and of also adopting further criminalization of terrorism. Last Friday, on 25 September 2020, the Swiss Parliament adopted two controversial laws. One is entitled Terrorism and Organized Crime and aims at implementing the Council of Europe Convention on the Prevention of Terrorism of 2005 and its additional protocol of 2015. The other is entitled Police Measures to Combat Terrorism and introduces numerous administrative measures against potential terrorists. This is not my wording. It comes from the law. So imagine that we have a Swiss law talking about potential terrorists. They are defined as individuals who could be engaged in terrorist activities. The administrative measures that are envisaged in this law, which we can call the MPT for the purpose of this panel, these administrative measures are quite far-reaching. They involve, for instance, the obligation to appear and participate in interviews with cantonal or municipal services. They include a ban on direct or indirect contacts with specific individuals or groups. They involve also the prohibition of leaving or entering specific areas or specific properties. They include the prohibition of leaving Switzerland. They also include assigned residence, one of the most striking features of this MPT law. And lastly, they include electronic surveillance. Now, a number of international lawyers and human rights activists have voiced their concerns in relation to the potential impact of those laws on human rights, humanitarian action, and IHL more broadly. Regarding the first law, so terrorism and organized crime, the good news is that after having pressured by a number of humanitarian organizations, such as the ICSC, MSF, Geneva Call, the Parliament has introduced an exemption for humanitarian activities. I'm very proud to say that Professor Sassoli, who is teaching the IHL course in our LLM, has also played a key role for the adoption of this exemption. He pleaded in favor of that exemption in front of the Parliament. Now, it does not mean that that law is perfect. It obviously still raises concern in relation to international law, and we will discuss that with Roberta. Now, the bad news is that the second law, the MPT, has been adopted despite numerous interventions. We had even interventions by several UN special rapporteurs, including Special Rapporteur Nils Meltzer, who is with us today, tonight, to discuss about that law. We had also academics voicing their concerns in relation to the MPT. The University of Lausanne has organized an open letter to the Parliament and the Executive, which has been coordinated by Cass Lubishtani. It gathered a number of signatures, but nevertheless, this law has been adopted. To discuss these new laws, I'm very happy to introduce you to our panelists. I'll start with Dr. Sandra Krehenman, who is the thematic legal advisor at Geneva Call. She used also to be a researcher at the Geneva Academy who worked on foreign fighters. Then we have online Ms. Françoise Bouchet-Saulnier, who is International Legal Director at Doctors Without Borders, MSF. Thank you very much for being with us tonight. We have also Roberta Arnold, who is an attorney, a Swiss attorney, and who is also specialized in international humanitarian law. So she has these two hats, being able to explain us the first law under the Swiss system and also the impact under IHL. Then we have Nils Meltzer. I think he doesn't need any introduction anymore, but he's a special rapporteur on torture and other CIDT. He's also our human rights chair, and he's a professor of international law at the University of Glasgow. And last but not least, we have Mr. Ilya Sobol, who is a PhD candidate at the University of Geneva, and who is working with me on the project Counter-Terror Pro Legem. He wrote a blog together with me on EGIL in relation to the NPT. So now, for the organization of the panel, since we have two laws to discuss, I suggest that we start with the law called Terrorism and Organized Crime. And I will have a few questions for our panelists. So we will start with Sandra, then we will go to Françoise, and we will finish with Roberta. Each of the panelists has 10 minutes max. I will try to keep the time so that we have enough time for questions at the end. So my question to you, Sandra, is can you tell us about what Geneva Call has been doing in order to make sure that this exemption was adopted? Are you happy with the exemption that has been adopted in the Swiss law? And what is the importance for your work at Geneva Call to have this exemption?
Well, thank you, Gloria. Before I start answering your question, let me just say also how much I appreciate that you and the Geneva Academy host this event. I think it's one of the few, if not the first time, that the Geneva Academy has a Swiss-focused event. And not just because this is about Swiss legislation, but also, as I'm sure you're going to discuss, this is also taking place against the broader background of counter-terrorism laws. And then within Switzerland, I think it's worthwhile to remember that this is actually the first time that Switzerland is getting a comprehensive counter-terrorism legislation. So far, we only had a limited provision on terrorist financing. And still, before going to your question, I think it's also worthwhile to highlight what you said before, now that we're actually dealing here with two laws. And of course, in one way, they are separate. You have the criminal law, and then you have the administrative measures. But at the same time, there's also a link, because we have been witnessing an expansion of the criminal law space. And then corresponding to that, we have an expansion of what is the pre-criminal law space. And so we just start to cover broader and broader range of conduct. So for your question about the Swiss law, maybe let me give some background of what the Swiss law initially said. So the Federal Council has tabled a bill precisely with new terrorist offences as a way to implement the new Council of Europe Convention and its additional protocol. So strictly speaking, as a decree in order then to implement this. That included a provision that was criminalizing participation, if one could broadly term terrorist organizations, but also support to such organizations. Within that support notion, I think there were two elements which are worthwhile to flag. One of them is that it wasn't just support to the criminal or terrorist activities, it was broadly speaking support. And I would always say it wasn't even material support, it was just support. And then the notion of terrorist organization was defined by referring back to terrorism, you know, an organization that aims to achieve its aim by spreading terror or compelling organization. So it was potentially also very broad and could capture any armed group. There was also a difference with the US legislation, you know, where it's at least about foreign terrorist organization, which is a definite list that is by the Department of State. So for us, that raised the possibility that our activities could potentially be captured under that law, that to disseminate IHL to armed groups that then may be considered terrorist groups by a judge, that this could actually mean this would be a way of providing support. So at the very first beginning of this process, the Federal Council had a consultation procedure. And as part of that, we submitted all the way back in 2017 a position paper. ICRC submitted one as well, also requesting that there actually should be an exemption. That was unsuccessful. There was no exemption when the bill was tabled to Parliament. There was a message of the Federal Council that carries some legal weight in Swiss law and said this is not intended to target humanitarian organization. But at the end of the day, for us, it meant that there was still the possibility this could capture humanitarian activities and be just another building block in all the obstacles you face under counter-terrorism legislation to begin with. So what we then did is, you know, you intervene in the parliamentary process together with other humanitarian organizations where you write letters, you distribute flyers and try to speak directly to parliamentarians and raise their concerns and try to persuade them why it is important for you as a humanitarian organization that there actually would be such an explicit exemption, including, you know, even if you accept the argument, okay, this is not intended to target humanitarian organization, which is something we hear in many contexts, but then you say, well, then in order to increase legal security and the predictability of that law, then let's have an explicit humanitarian exemption and not leave it open to interpretation. This then could change in the future. So, and then, as you said, I'm quite happy to report that at least in this respect, you know, we have been heard and Parliament listened to the humanitarian organization and at the end of the day did decide to add an exemption for the humanitarian services provided by humanitarian organizations in conformity with Common Article 3. And I would like to stress what you said at the beginning. One of the crucial actors in this process was indeed Marcus Sassoli. Now it's the humanitarian exemption wasn't even on the table for Parliament until he attended a hearing of one of the preparatory commissions and he pleaded for including such an exemption. And then throughout the process, he very generously also provided, as always, with expertise and with follow-up input if necessary. So I think in the second part of the panel, you will think expertise and experts have no role to play in the world of politics. At least when it comes to the humanitarian exemption, they did have a role to play in the world of politics. And if you look at the discussions in Parliament, you can see Professor Sassoli mentioned repeatedly. So he's indeed in many respects a little bit of the father of that. Are we happy with it? I mean, we are happy that there is a humanitarian exemption. No, I think that is very important for us to get, not just as part of the Swiss law, but we would also consider that if Switzerland, as a depository state of the Geneva Conventions, does not have a humanitarian exemption, that would also have a very bad signaling effect to other states. And that as a depository, they do have a special responsibility to also comply with IHL and not to provide potential legal obstacles. That's having said that, it's, as you said, you know, I think there are broader structural concerns about the package. So that it's in a way a bittersweet, but it was a big success that you did at least get the humanitarian exemption, and then will also allow humanitarian organizations actually to keep on providing humanitarian assistance and protection to people in need, including people in need who may be affected by host country counter-terrorism laws. How important is it for our work? I think for us it is important. On the one hand, we are a Swiss-based organization. So as a Swiss-based organization, if our home country does not provide us with a humanitarian exemption, we have a lot of questions to ask. I think for humanitarian organizations, this is also a question of duty of care towards your staff. I mean, we speak about humanitarian activities and humanitarian organizations, but as you said, at the end of the day, this is in the realm of criminal law. So at the end of the day, this means staff members of humanitarian organizations who run a legal risk in addition to all the other risks they're already running when they do exercise the humanitarian activities.
Mm-hmm. Perfect. Thank you very much, Sandra. It's really clarifying the context, and we see how important that is. So let's now turn to Françoise, who is online. So
yeah,
thank you for being with us. Can you tell us for MSF how important that exemption is, and whether these counter-terrorism laws that have been adopted in Europe have impacted your work?
Mm-hmm. Thank you very much again for organizing this this event. I think I will also say that what is extremely interesting in this case is that we have the two laws, and we see that there's one good news on one side and a real concern regarding the police, the second law. And I think it's exactly what happens to humanitarian organizations in the field, because the law is something, and you can imagine if there's not even a humanitarian exemption in the law, that actually at field level, we are confronted with all the administrative and security measures that comes from the law that are so broad, that are carried out in many instances by militarized security forces, and that it contributes a lot in blurring completely the line between the protected status under IHL of humanitarian action and of protected victims of conflict, and the criminalized status under counter-terrorism regulation and practices. And it's so important to link both. So of course we are sad that the second law today is not a good one, and it's very important that we carry this message, but it's very important also to acknowledge that starting with the humanitarian exemption is a first step to acknowledge the damage caused by the law. I would say the non-intentional damage caused by those laws aimed at protecting law and order with regard to the victims, the humanitarian action, and actually the whole system of law and order in situation of conflict. And we see the problem in a country where there's no war at the moment, and we hope never. But this is exactly the same legal setup that we find out and we have to live with in country of operation. And of course, there's far less lawyers concerned about that. So I will go quickly over the slide to the first one, please, to show that there is an overlap between counterterrorism and humanitarian action that is actually very practically undermining the IHL status of protection. I go very quickly, but you have it on the slide. The status of patient under IHL is very clear. They are out of combat. They must be treated. Under counterterrorism, they're criminals. And we enter a complete gray zone where actually our hospital can be raided to arrest those people. Our medical care should not be done within respect of medical confidentiality. The kind of duty to report or to send those people directly is everywhere and very, very gray, I would say. And when you have to negotiate with big guys with weapons, it's even more complex to negotiate. The status of population, it's very clear under IHL, they are victim of conflict. But under counterterrorism, if you take Nigeria and the Borno area, everyone consider that the one that remains under the control of terrorist group or criminal groups, I prefer to say criminal because you have to be designated and as terrorists, but those who remain under the control are considered after a while to be accomplices and to be support of terrorists. And we see the problem we have with the issue of the family of the fighters, but also of the remainers in those territories. The status of the medical and humanitarian personnel, again, under IHL, it is quite clear, but under the other body of law, we are supporting criminal hiding. You know, medical units are supposed, and we are accused on a daily basis, this is in Cameroon last week, to hide, hospitals are accused to be placed for hiding criminals who are wounded and who are treated. Huh? Okay. For the humanitarian and medical assistance, of course, it is under, it's a duty under IHL, but it is considered as material support or support to criminals under the counterterrorism system, I would say. The status of access, again, it's a duty under IHL, but it falls under the illegal entry on territory controlled by criminals under the counterterrorism system, and it has a huge impact everywhere on our own staff, be they expatriate, coming from many different countries where they have to be accountable when they come back, or be authorized when they come in, and it goes with some lack of independence and neutrality, of course, be it for national staff that are directly exposed to the pressure of the authority, which is the one of criminalization. And of course, the status of humanitarian dialogue under a Common Article 3, it has no impact on the legal status of the party. And of course, it is the first step to start operating humanitarian activities, because you have to discuss with all parties of the conflict, the state and the non-state. And under counterterrorism, it is considered as complicity, and sometimes even more. And we have had people in MSF being accused, being arrested, being interrogated for all those different types of offenses or blood offenses. And we even had a number of experience under the attack on hospital, where actually we were attacked because we were hiding terrorists. And this falls under the kind of category of targeted killing. So again, the attack on hospital was not a coincidence. It's when we treat some kind of wounded that we receive this type of threat. So it's not only legal threat, it comes with direct security and attack. Next, please. So just to give you an idea where actually we found out our own practice that we had a problem because city regulation and practices were really overlapping the IHL. I list a number of them, and not few. We have the whole Sahel region, we have the whole, I should also put Afghanistan. So almost everywhere where there's a kind of conflict and counterterrorism, we have problems. We search for element of clarification, stating some kind of exemption language. We found very, very, very few. They were old. Australia and Canada were quite old. And all for the others, they are new. It's a strong advocacy that is needed, a very strong advocacy, and advocacy that lasted for many years. The most recent example were some exemption for specific offenses like the entry on the territory, while all the rest remain, blurred. So again, if you go next, I'm going quite quick, but it's for the sake of solve the debate. The weak point of IHL and counterterrorism is that counterterrorism is criminal law, and so it is included directly in domestic law, and all judges, all policemen, everyone knows about that. IHL is poorly included, part is included in domestic military manual, and this inclusion mostly referred to the conduct of hostilities, very little on law enforcement, and very little on humanitarian assistance. It's also poorly included in domestic law regarding, for instance, the medical immunity. You know, no one shall be punished for having carried out medical activity compatible with medical ethics, whatever the circumstances. This is Protocol 1, Protocol 2. You'll never find it in any criminal law. And of course, there's no point to put that into a military manual. But this is crucial. And finally, it has to be, you know, pressure and advocacy to the UN Security Council to force UN Security Council to remind that states must take into account the impact of counterterrorism on their obligation under IHL. This was necessary to open a space for discussion with states because, be it France, Switzerland, or all other countries, let's say Western country, they would say, no problem. We will never mix such organization as yours with terrorists. Next, please. So our strategy in MSF was to really advocate for exemption based on proof, you know, going into comparative analysis of, for instance, I don't know, Nigeria, criminal law, terrorist law, and military manual to identify the loophole, you know, the element where we were just, you know, without answer. And then we, of course, started to push for this exemption at all levels. And we saw that going at the UN level was quite important because when we negotiate at field level, all states, Nigeria, Iraq, all of them, Chad, they say, but it is your country who push us to adopt such rules. This is a kind of international obligation to prove that we are consistent in fighting terrorism. So we have to adopt the most strict regulation in our country, and we cannot invent a humanitarian exemption if it is not in the UK law or that we copy paste, or in the French law that we copy paste, basically. So that was really a big concern because there was a kind of difficulty to address the issue at, let's say, Western level, and a difficulty, of course, to address the issue at country level, country of operation, humanitarian operation. So actually, we worked on both sides to include in our own memorandum of understanding element of language that we found in UN resolution, for instance, the one I put in Nigeria. At least in the Nigeria commitment to MSF presence, they say that they will ensure, in accordance with its obligation under IHL, that national regulation and IHL, when applicable, of course, that their counterterrorism legislation and measure, that are very important, do not impede humanitarian and medical activities by Médecins Sans Frontières or its engagement with all relevant actors as foreseen by IHL. So this is a kind of contractual language that we put in our MOU just to secure some space and make sure that when there's a problem, we're able to say, yeah, but we discussed already this issue, but it's quite difficult. Next, please. I put you some example of definition that are quite old, and you can go to the next. We are very happy that we managed to get in May this year an exemption in Chad. It is the first time we get an exemption in a southern country where we had huge operation and counterterrorism is an issue. So we managed to get that. If, of course, no one is really aware because Chad is not making its own publicity. That was, of course, the result of big advocacy by the humanitarian organization. And you see activity of an exclusively humanitarian and impartial character carried out by neutral, impartial humanitarian organization are excluded for the scope of application of this present counterterrorism law. So this is more UN's resolution language. And if you go next, we have the new Swiss law language, which refers to service humanitaire given by a humanitarian impartial organization, according to Article 3 common to Geneva Convention. The reference to the Article 3 common is very important for us because it is within this article that is said ICRC and other impartial humanitarian organizations may offer services, may enter into special agreement with all parties to the conflict. Article 3 applying to non-international conflict. It's obvious that we are asked to enter into agreement with non-state actors that are, of course, qualified as criminal under domestic law by the state party, but they may also be designed as terrorists without jeopardizing the prevailing status of IHL with regard to humanitarian assistance. You can go next. I say it. So the Swiss law is a step forward clearly for us, because it creates a precedent and a kind of standard language. It shows also that it is possible to draft such a clause. In the advocacy, we have MSF with a number of other countries, even French-speaking countries. We're still at the level where they say it's impossible to draft. The Ministry of Justice will never accept, because if you draft something, you will create a space for terrorists. So Swiss proved that it is possible to draft and vote and enact such a clause without jeopardizing the ability to prosecute terrorists. We very often say that the difficulty to prosecute terrorists is not coming from any kind of potential humanitarian exemption, but about the difficulty to catch them. So we cannot be the kind of collateral damage of the difficulty of some judges to prosecute people with few elements of evidence, of course, because the crimes happen far away. So this is something we have to be very strong, because otherwise the criminal law has been so open, so widely open for the sake of conducting trials that it destroys all the rest. So it's also a step forward for us, because it shows that it is necessary and useful to clarify the scope of protection of IHL toward counter-terrorism law and practice. Because again, a number of countries say you can rely on the judge wisdom. And it shows that relying on the judge wisdom is not a legal option. We cannot agree with that. You can say whatever you want about the Swiss judge or French judge. I may have a different opinion anyway, but we are speaking about a Nigeria military court. We are speaking concretely about a Congolese special military tribunal who prosecutes and sentence an MSF person. So this is what we are speaking about. It's also proved that and reiterate that humanitarian services are legitimate in situation of conflict on counterterrorism and conflict. And frankly, it's not useless at the time, and it may be even more useful in the coming time, because the consensus on humanitarian action is very weak at international level. The consensus on terrorism brings the Russian, the Chinese, the US, and everyone together. But it is a very dangerous consensus, this one. It's fulfilled the UN Security Council request in its resolution on counterterrorism. So it also leads by example, because it shows to other countries, and I hope Western countries, that this is an absolutely and mandatory requirement to protect humanitarian action. When states like the French wanted to take an initiative for protection of humanitarian actors, we don't need, new system to fight against impunity on attack on humanitarian actor. We need to be restored in the legitimacy of what we do first. And also it enables humanitarian organization, this is the most important, to enter into dialogue with all parties and provide most needed humanitarian medical assistance, because you can be sure that already last week we used the draft to show that this is something that must be transferred into all country legislation. This is the first fight. The second, and the one that remain, will be the one that we have to tackle, the one referring to the police and administrative security measures. That remains, of course, a tremendous concern. But I think without this first success, it would have been impossible to push for the rest, because today we are already, as humanitarian actor, too weak and too pressured in almost all country of deployment and all country of headquarters.
Excellent. Thank you very much, Françoise. I think you showed how important advocacy is, not only at the domestic level, but also at the international level with the UN. So now I will give the floor to Roberta, and I will ask Roberta, why did Switzerland adopt this new law on terrorism and organized crime? Was it really necessary to implement the Council of Europe Convention? And what will change actually with the adoption of this new law?
First of all, good evening, everybody. I hope you can hear me well.
Very well.
Perfect. I'm very pleased to see the panel. I see some colleagues that I've been in contact with, or I have lost contact with for several years. Experts in IHL, in counterterrorism, in foreign terrorist fighters. We have the newcomers, the younger generations, and I really joined Sandra in making my compliments to you, Gloria, for bringing together a panel addressing different aspects of the new proposed legislation on counterterrorism, which was actually adopted. So we just have to wait its entry into force. You mentioned that I'm actually an attorney. I do not practice as an attorney, though I'm focusing on these issues as an academic, and well, it's not a secret that I'm a former public prosecutor. So I looked at the message and at the draft legislation with, how should I say, I was a little bit siding sometimes up with the law enforcement agents and sometimes with the NGOs in looking at the legislation, because we realized that in practice, when you have to find answers to the security requests, you do not necessarily have the time or also the dogmatic knowledge to really look at all the aspects and implications under international law, human rights law, IHL. And maybe this has also to do, in my opinion, with a big shift of paradigm we had with the 9/11 attacks. We might not have to discuss about these issues if the 9/11 attacks had not happened, and it had not been answered with the military methods for countering terrorism. And why am I saying this? Because before 9/11, I think that terrorism was considered by most as a pure criminal offense. With the 9/11 attacks and the US answer by invading Afghanistan and all the following UN Security Council resolutions, the statement that there's a war on terror, I think that we brought into play sometimes an overlapping application of counterterrorism legislation and IHL, which brings into play the problems that have been raised by Mrs. Boucher-Saulnier, by Sandra. And when law enforcement agents and the politicians are called by law enforcement agents to act, I think that this dichotomy is not necessarily present. You need to act. And this new legislation was adopted because especially the Federal Attorney General's Office, which is entrusted with the prosecution of terrorist offenses, realized that the existing legislation was not strong enough and efficient enough to tackle the problem. And in particular, with then the implementation or the first steps to implement the European Convention, the Parliament, in a later stage, let's say, converted the decrees, the emergency decrees of the executive into an emergency law to counter groups like ISIS, Daesh, and Al-Qaeda, stating that these are terrorist groups and that mere participation to them already constitutes an offense. Therefore, alleviating law enforcement agents and the prosecutors to really qualify the group. And at the same time, however, this emergency law was restricted to IS and Al-Qaeda. and not necessarily to other forms of organized crime that we may label as terrorism. And so the Federal Attorney General's office often had to rely on the provision of criminal organization, which had been initially thought for organizations like the mafia. So this is why we had the requirement that the structure of these organizations had to be secret, because in the 80s, 90s, when we had mafia-like groups, the idea was that they could hide behind the anonymity of the structure to commit crimes. So the idea was that you could actually convict someone for mere participation, regardless of the fact that you could not prove an accusation of this specific person with the commission of a specific crime by this group. But this proved to be a problem. And so the jurisprudence had to develop, itself to expand this provision to terrorist organizations. But we find very little reference in the message to the adoption of this provision many years ago to terrorist groups. So this is why there have been requests really to amend this provision. And we also have the provision on the financing of terrorism that found very little application because it wasn't really clear how to interpret, or the threshold is very high. So basically the parliament decided to listen to these concerns. And another big concern was associated with the speediness of mutual legal assistance. For those who are not necessarily acquainted with the criminal law, basically you have a state that is investigating on a case, but it turns out that most of the evidence is abroad in a different state, and therefore you have to apply an international judicial assistance request. You can't go abroad and investigate on your own because you would breach the foreign sovereignty, and that's also a federal crime in Switzerland. But the requested state is only going to help you if the crimes that you charge the person with constitute crimes also in that state. And sometimes it very much depends on the readiness of the other states to cooperate, and the procedures are very lengthy. So the other request was really to find methods to speed up this process. So what happened? The parliament decided to revise these provisions. It decided that the emergency law against IS and Al-Qaeda, the anti-IS law, was going to be integrated in the new Intelligence Service Act in Article 74. So people who participate to groups, organizations that are on a list based on decision of the United Nations can also be prosecuted. But additionally, you have 260 ter on organized crime that has been revised. So now basically the legislator decided to crystallize the definition of terrorism by saying that any person who participates to an organization that is intended to, or that commits violent crimes aimed at intimidating the public, or to coerce a state or an international organization into carrying out or not carrying out an act is liable. And this new definition has been strongly criticized for being too vague. The big concern is that the courts are going to develop a contradictory jurisprudence. And at domestic level, I read some concerns from NGOs that divergent jurisprudence might develop at cantonal level, although I'm not sure that that's really the case because, as we said, this is a federal crime. So only the Federal Attorney General is going to be competent, and cases charged or led by the Federal Attorney General's office are only adjudicated by the Federal Criminal Court in Bellinzona. So it will be the task of the Federal Criminal Court to develop a jurisprudence really interpreting the elements of this crime. We have some precedents addressing, for instance, the status of the LTTE, the PKK. There has been a very, very recent case, an extradition case in June that was adjudicated by the federal court even, because the case went up to the federal court. And the other concern is are we going to have a univoc, a uniform jurisprudence at domestic level? Are the courts going to have the know-how to do this? And if we think that the European Convention is going to be implemented by different states who are parties to it, can we ensure that we're going to have a uniform interpretation of what a terrorist group and as a terrorist offense is at the European level? So this is the first concern. For instance, the European Convention says that a terrorist offense is understood as one of the offenses enlisted in the already existing UN conventions countering terrorism. So the one on hostage taking, the hijacking of aircraft, the one on the safety of maritime navigation, conventions that were adopted after various terrorist attacks in the past. And the additional protocol also says that the participation to a terrorist group means participation to a group that aims at committing terrorist offenses. So we always go back to the sub-definition of terrorism, of sub-forms of terrorism that are addressed as specific conducts. But in the Swiss legislation, we see that the legislator decided to adopt a definition that is already contained in the provision on the financing of terrorism, and which in my view is very similar to the anti-terrorism provisions in the Geneva Conventions and the protocols. So I'm moving back to IHL, because in IHL, we see that if the hostilities are conducted in a way where the primary purpose of an attack is to terrorize the civilian population of the other side so that it will be demoralized, it's no longer going to support the adverse party, these now constitute a war crime. This position that this violation of IHL is a war crime was developed by the ICTY, by the International Tribunal for Former Yugoslavia. And I see that many of the elements are similar because we have the element of fear, of terror, of intimidating civilians who have nothing to do with the decision taker. And the real target is the decision taker, which is normally a state or an international organization. And the big question is what the court, the Federal Criminal Court, is going to do. Because as said, in the previous decisions on the LTT and the PKK, for instance, they dealt also with the question what the primary aim of these groups was. Why were they created? Were they created really to commit crimes, or were crimes and terrorist activities a side effect of their primary aim to defend the identity of, well, with the LTT, I'm talking about the Tamil ethnic group, with the PKK of the Kurdish group. So we see that the courts will really have to study in detail the political and the social context, the historical context, and also question whether these groups were in fact non-state parties to an armed conflict. And I think this is where the problems may start, as Mrs. Boucher-Saunier mentioned, because as also the ICRC highlighted in its 32nd International Conference of the Red Cross and the Red Crescent in 2015, there is a tendency to consider all acts committed by a non-state actor as terrorism, even when the acts are lawful under IHL. And this is due to the fear by states to recognize armed conflicts, because this might imply in their view the legitimization of non-state actors. But the risk is that although terrorist acts are considered as crimes also under IHL, not all acts of violence that are considered as terrorist offenses in peacetime are necessarily violations of IHL. So this is where the problems start, because then the question will be, what happens if there is the member of a group that is involved in an armed conflict and at the same time commits terrorist attacks abroad? What status shall we grant to this person? Why is this person going to be tried? Is he going to be tried for acts of violence that will be legitimate under IHL? And are the charges going to be brought for terrorist acts or for war crimes? And for instance, Professor Best did a very good analysis, in my opinion, last year about this new legislation, saying, for instance, with ISIS, it would be a little bit reductive, for instance, to claim that they're a terrorist organization limiting itself to commit terrorist crimes, because they did much more. There were much wider scale atrocities being committed that should be tried under the heading of international crimes. So to sum it up, I think that one of the big problems would be the choice of what legal regime to apply to prosecute for war crimes, for terrorist offenses, what status to grant to the accused, because depending on the applicable regime, his conduct might not be necessarily a crime, but if we decide that mere participation to a group labeled as terrorist group is sufficient, then courts might not necessarily look at this. Another big problem, in my view, will be, again, rely to mutual legal assistance, because as in the Lockerbie case, the basis of these treaties is still the outdated.
Okay, sorry, Roberta, can you wrap up so that we can also discuss about the second law?
Yes, I got carried away. I'm sorry about this. So to sum it up, there will be still the same usual problems that we had in the past with the UN conventions on extradition, etc. There is going to be a potential confusion about the legal status of those involved. And a question for international criminal lawyers is going to be, for instance, if I have someone who's going to be tried for terrorism for participating to a terrorist group, which is at the same time a non-state actor in an armed conflict. How do we go about the compliance with the principle of command responsibility? Can we still expect non-state actors and organized groups to have their own courts and to punish subordinates who committed crimes when at the same time they're labeled as terrorist groups? What is going to happen if you want to invite them to the negotiating table for peace? Can we still invite terrorist groups? So these are the questions that I do not necessarily have the answers to, but this might be the topic for further research.
Great, thank you very much, Roberta. I think you showed how, from the perspective of maybe Switzerland or from a prosecutor, it could be an advantage to have this type of law. And at the same time, you highlighted that from an international law perspective, you might have a situation of conflation between counter-terrorism laws and international humanitarian law. So now let's turn to the second law, the MPT on the administrative measures. So let's start with Nils. Can you tell us what is the potential human rights impact of the MPT?
Yes, thank you, and well, good evening to everybody, and thank you, Gloria, for organizing this event. As many of you know, I've been very vocal about this law on preventative measures, and I think, first of all, we have to be clear and honest that terrorism is a problem, and it needs to be addressed. And sometimes, especially in terrorism, just reacting to terrorist attacks is not enough. You have to be able to take preventative measures. So I'd like to be fair about this. It's not about trying to prevent preventative measures, but let's do it according to the law and in order to ensure that the values that make our societies remain intact. And so I'd like to quickly take you through what in my view is the problem. And we'll split it up, I think, also in two different parts, and then why this is a problem, and who else thinks it is a problem, and so these are kind of the three, and what's the bigger systemic implications of this. So what is a problem? Obviously, if you look at preventative measures, you can look at the measures themselves, and I think Ilya will be looking at that and the compatibility of the measures themselves with the human rights law. But then the one aspect that I want to look at more specifically here is, well, who are we going to apply these measures to? So what's the personal scope of applicability? And here I see a monumental problem in what Switzerland has done. I can still not, I still try to wake up from a bad dream. And I'm not exaggerating and I'm going to explain to you why. So the law on preventative measures in the area of counterterrorism defines the potential terrorist so who has not committed a terrorist offense, but is not a suspect of having committed an offense, but someone who might commit such an offense. And then the law defines what is a terrorist activity. And now classically, there is no consensus definition in international law that is absolutely applicable in all jurisdictions. But by and large, all accepted definitions combine three elements. So there is the spreading of fear and terror through the threat or the commission of a violent crime, such as kidnapping, murder, or serious injury. So these two elements, spreading terror through threat or commission of such a crime, and there is a political motivation. So these are kind of the basic elements that you see in the Security Council definitions, that you see in the criminal code of Switzerland. And then you have it also in the Intelligence Service Act. It's always formulated a bit differently, but you always see these three cumulative elements coming back. And now this preventative law defines terrorist activities all of a sudden alternatively. So there is the political motivation that is a prerequisite, but then so these political goals, if you want to achieve those, either by the commission or the threat of a serious crime, it no longer has to be a violent crime, but a serious crime, it could be a financial crime, theoretically, or through the spreading of fear and terror. So if you want to change the political order of this country, which, you know, direct democracy is something we do all the time, we just voted again to try to, you know, some people wanted to change the political order, and I'm not ridiculing it, that's a normal motivation in democracy. It's the means that are that count. And today, under this definition, it is no longer required that there must be at least a danger of a crime being committed at any point. It is sufficient that you spread fear. So if Greta Thunberg comes to Switzerland, or not even in Switzerland, she just says that if we don't change our political order now, we will all die. Theoretically, this would be terrorism according to this law. According to the letter of the law, you can apply the law and it would cover that. Now, I'm not suggesting this was the intention of the authorities, but again, as has been suggested, the wisdom of the authorities is not something we should rely on. Under this definition, what separates us from a police state, an authoritarian police state, is the common sense of the authorities in applying this definition. And the common sense, as we know, is not the most common of all senses. And so this is a formal issue I already have here. And the government, when it proposed this law to the parliament, in its message to the parliament, it said, we're not changing the definition, we're taking it from the Intelligence Service Act. But it's not true. If you look at it, they took only half of the definition. Because the definition in the Intelligence Service Act presupposes that there is a threat of violence or the existence of the state or to life and serious injury, essentially through and then it comes this definition of an act that spreads terror. And this first prerequisite that we have this threat in the first place is no longer necessary. They just skipped it and only copied the second part of the definition. So this is and why is this a problem? As I said, I don't think the Swiss authorities are planning to take preventative measures against Greta Thunberg. But the problem is this, that if we should have a couple of terrorist attacks in Switzerland, public opinion will change. The practice and the criteria of the authorities change overnight. We've seen it with 9/11, and we're still suffering from the consequences, and this is part of these consequences. All of a sudden, authorities become extremely expansive. And so this is one, there is a risk that how this might develop based on this law. The second thing is, as has also been suggested, counter-terror laws are copy-pasted by many countries from example countries. This can be major powers like the UK, US, or others, or it can be model countries like the Swiss. I can assure you that countries like Turkey, Iran, China would happily have a definition like this, where they can say, oh, these people are spreading, fear, so they're terrorists. We have to take preventive measures. And I can tell you, as Special Rapporteur on Torture, every day I receive 10 to 15 interventions, a request for intervention, and many of those relate to people who have ended up on some kind of a terrorist list, suspect list, and have been arrested at some airport, and then locked up and tortured in a country where you can't get them out anymore. And this is the second problem. The Swiss intelligence service, as has been said, cannot investigate in another country. Where do they get this information from? Not from Le Matin. Yeah, they get it from foreign intelligence services. Obviously, in practice, they cooperate all the time. This is an intense exchange that happens all the time in secret, and it's necessary because you can't collect intelligence about Pakistanis living here without having people in Pakistan. So it's the Pakistani intelligence service, obviously, that will share this information, or the CIA, or the German intelligence service. But then our lists go back to them. Let's not make a mistake about it. Whatever our authorities say, I can tell you that this exchange goes both ways. So we think, oh, there's no problem. We put him on the list, we'll watch him a little bit, and if he's not dangerous, we'll take him off the list again. An Egyptian who has lived here for 30 years, his cousin, who has fundamentalist ideas, calls him once in a while. So he ends up on the list in Switzerland. Then he goes visits his family in Sharm el-Sheikh, and he gets arrested. And the next thing you hear is from me, because I received the intervention request from his family saying he is in Torah prison in Egypt, he's being tortured. I mean, I'm just taking this as an example, not to single out Egypt, because there's plenty of countries like this. And there's nothing you can do. And he's in there because of a determination of the federal police in Switzerland. This is what's going to happen. And that's why it's so important that we are careful about this. Yes, let's fight terrorism, but let's define it properly. Just when you want to have a vaccine against COVID, you have to know what COVID is. You don't just have a vaccine against everything. So this is important. Now, who has seen that this is a problem? It's not just me, there have been 5 special rapporteurs of the UN intervening formally with the Swiss. The Commission for Human Rights of the Council of Europe has intervened personally, has called on the Swiss to stop this. The Federal Department of Foreign Affairs of Switzerland has protested formally to the Ministry of Justice and demanded that this definition be changed. And they have just said, we've taken note, but decided against it. And their explanation is basically, we had to weigh security against freedom. But I don't have an appropriate term to say what this is. It is so frivolous and so short-sighted to adopt a definition that will have consequences like this. And not to speak of all the NGOs, the academics, we've had a letter of 60 academics, Swiss legal academics, just a couple of days before the vote in the parliament. We've really had another press release calling on parliament to listen to us. It's not that you should not have this law. Just put an and instead of an or in your definition and bring it in line with what rule of law states think terrorism is. And this brings me to my concluding remarks. I think the larger implications of this. But why I'm so angry about this is because it could have been fixed so easily. I'm not saying the other aspects of the law don't raise some problems, but this is a major failure of Swiss institutions to listen to the Council of Europe, to listen to the United Nations, to listen to special rapporteurs, to its own academics, to its own Ministry of Foreign Affairs. They don't even listen to them anymore. And we can get this through, and the parliamentarians can't get their act together and realize it's not even been debated, these issues in parliament. What does this mean if a country like Switzerland, where the institutions are still fairly well functioning, can't fix a thing like this in a small country that doesn't have a real terrorist threat every day on the streets. If we can't do this in a situation of peace and control, what do we expect other countries to do where bombs go off every day? And what this means for our ability to respond to these threats globally. I'll stop here and I'll hand over to you, Ilya, for the preventive measures, right?
Thank you very much, Nils, because I think sharing your perspective is absolutely crucial. You show not only the direct impacts of this kind of laws, but also the indirect impacts in other countries. And I think it's very important to show also all the actors which have spoken against that law. So thank you very much for that. Now we are going to focus on one specific measure that is provided in that law, and that is assigned residence of potential terrorists, which could go up to 9 months. So Ilya is going to analyze whether this is in conformity with the European Convention on Human Rights.
Thank you.
You have the floor.
Thank you. I'm very glad to be part of this discussion this evening. And as a former student of the Academy, I'm twice as glad to be back here in a kind of a new and different capacity now. In the following 10 minutes, I will speak about 2 issues surrounding the assigned residence under the federal law, and that is the implication for the right to liberty and fair trial rights under the European Convention on Human Rights. Now, the restrictive measures that the federal law has designed now is not really something new when it comes to the contemporary, let's say, counterterrorism arsenal of states, either in Europe or elsewhere. What is new is that it kind of defies the logic of how states saw control orders in the past. What I mean with this is that in the past, states tried to act in a way that wouldn't engage Article 5 under the European Convention on Human Rights. So they would design these restrictions in a way where they wouldn't constitute deprivation of liberty. Now, the reason for that is because Article 5 gives an exhaustive list of grounds on which a state can rely as a justification for deprivation of liberty. And the situations in which states impose control orders, they don't really fit into any of those grounds. So they wanted to avoid it because it would ultimately just lead to a violation of Article 5. Now, there is a provision, which is Article 5.1c. So we cannot see it here, but when it says, when it is reasonably considered necessary to prevent a person committing an offense, that provision is well established as being applicable to pretrial detention. So you cannot detain someone who hasn't really been suspected in committing a crime, which is exactly the scenarios where states engage in control orders. Now, circle back to what I was saying. The way in which the assigned residence regime defies that logic is that authorities openly, explicitly acknowledge that Article 5 will be engaged, which is true. I wouldn't argue with that, because basically what assigned residence constitutes is something equivalent to a full-blown house arrest, where a person is not allowed to leave their house. They can be assigned to an institution even with a very, very limited list of exceptions. So it's a house arrest. So definitely the right to liberty under Article 5 is engaged. Now, what they're arguing is that Article 5.1b would be the provision that would allow them to engage in these practices, especially the second paragraph. So I have it in bold on the slides. It says the deprivation of liberty is allowed in order to secure the fulfillment of any obligation prescribed by law. I should clarify here, in the current scheme as it exists in the law that was adopted on Friday, a person can be assigned residence, subject to assigned residence when they violate an initial control order. So Professor Gojali has listed some of them in the beginning of our discussion. It can be a contact ban, it can be a ban on living in Switzerland, it can be an obligation to come to interviews. So once that initial violation is breached, then the authorities, the federal police, can order a person to be assigned to a residence. Now, I would say that the argument doesn't hold much water, in the sense that the current regime doesn't have much to do with actually securing the fulfillment of any obligation prescribed by law. I should say, as a lawyer, I should say that this is not an official translation of the text, but I think it's quite accurate. So there are two conditions when it comes to the assignment of residence. I'll start with the letter B here. That is the one that I mentioned. So one of the more initial measures have to be reached. So that's quite clear. Now, letter A says that there have to be concrete and current indicators that the person constitutes a considerable threat, etc., etc. So if one were genuinely read the law as having to deal with the securing of the fulfillment of the obligations, this person would have to conclude that the state only cares about the fulfillment of those obligations when, quote unquote, a potential terrorist didn't just breach the initial order, but also when they have evidence of concrete and current indicators. So if they don't have any concrete and current indicators, then they don't really care about the fulfillment of those obligations. So I would read this letter A provision not as a sort of a safeguard against the broader application of the law, but rather as an indication of what the state is actually after here, which is instituting what is basically preventative detention through the back door by relying on this provision of the European Convention. This is not the only reason why I think the law doesn't comply, especially when it comes to assigned residence. It doesn't comply with Article 5 of the European Convention. When it comes to individual cases, there would definitely be considerations of necessity and proportionality, especially when it comes to the length of the potential detention. 9 months is certainly a long time. One other thing would be a more structural one, perhaps, and that is, how would we decide that an obligation in question has in fact been complied with? Because under the convention, the detention can only last as long as the obligation is not complied with. So let's say the person would promise that they would come to interviews. Would that be sufficient to drop the assigned residence order? Because under the law, it kind of has to. So that's unclear. But these are other points. I don't have much time to go. Professor Gajali mentioned that I had a pleasure of co-authoring a blog post with her. We elaborate on these and other points there. So if those interested can check that out. I will say a few words about Article 6, which is an article that provides fair trial guarantees. Now, it is a related question because it kind of circles back to what is basically a punitive nature of the regime as it exists now, in the sense that a person is not deprived of their liberty in order to make sure that they actually fulfill the whatever obligation, but they are punished for not complying with the initial order. Now, the issue there is what is called a criminal limb of Article 6. That is, that Article 6 has criminal and a civil limb, and criminal limb is the one that applies to criminal proceedings. Now, the reason why it is of relevance here to the law, which is designed to circumvent the protections that are normally granted in a criminal process, is that it actually fails to do so. When it comes to the applicability of Article 6, the European Court of Human Rights doesn't just look at how the proceedings are called by the state. It also looks at what is in the substance. So a state can call the proceedings a disciplinary proceedings or administrative proceedings or whatever, but if they are essentially criminal proceedings in their nature, then the court would find that Article 6 have to apply. So a person in question has to be provided with all the proper fair trial guarantees. Now, in the law here, it is not quite clear whether the Cantonal Court of Constraint and Bern, which is the court that is assigned to sign off on assigned residence orders, will apply criminal law. I guess as far as we know, it's not going to apply it. And the point here is that there's a strong argument to be made that in fact these proceedings, when it comes to the assigned residence orders, would in fact constitute criminal proceedings. This argument was made, I should mention that Castro-Distani and Herman Monod, they wrote an article in Security and Law about this. They were, I guess, they were the first one to make it. And they convincingly show that when applied against the criteria developed by the European Court of Human Rights, these proceedings would in fact be criminal. So should that argument stand, that would most likely be a violation of Article 6 because proper guarantees of criminal law would not be provided. should that argument not stand, there would still be a question, because as you can see, the standard of proof here is concrete and current indicators. I guess it wouldn't be very controversial to say that this is not the standard of proof that we are accustomed to when it comes to criminal proceedings. I guess I don't have much time to go into the effectiveness question, so maybe we can pick it up later, or I can keep it to myself. And just maybe a final point, I guess it is to be expected that this law will face challenges, either in Swiss courts, and I guess eventually it will make its way to the European Court of Human Rights. And I would really bet my money on this law standing and not being found in violation of the convention.
Great, thank you very much. I have a quick follow-up question on that MPT, and in particular in relation to the assigned residence. If we consider that actually it's a kind of ersatz for security detention, would it be a possibility for Switzerland to decide to derogate from Article 5 of the ECHR, and would that solve the issue? Would then Switzerland be in conformity with the European Convention on Human Rights?
Yeah, I should have mentioned that the only way to, when not the only way, two ways when preventative detention can be in compliance with Article 5. One would be a situation of international conflict. When it comes to non-financial ones, I'm unclear, but this is not what we're discussing here. The other way would be for a state to properly derogate from that provision. I guess the first question would be whether Switzerland faces a proper sort of a threat to, I'm not sure about the formulation of the convention, but if there is an actual threat.
Public emergency.
Public emergency, yes, exactly. If there is a public emergency in Switzerland that would allow it to properly derogate for the purposes of engaging in preventive detention, I would doubt that there is, but if they did, well, yes, perhaps that would be the only way for the measures to comply with the law.
And Nils, would you like to add something on that?
I just want to comment on the judicial review question, just also as a practitioner, having worked in armed conflict areas after 9/11 and visited rendition detainees and seen all of this evolve for 20 years. I've also worked in the district court at some point when I was a young lawyer. Even if there is a judicial review, how am I as a Swiss judge going to actually review this? Because I will have to review whether the person is rightly on that list as a potential terrorist, and whether the measure is lawful, necessary, and proportionate. Right? So compared to a threat that has, that is based on information which is top secret, which will not even be revealed to the judge, because it's not really, it's just between intelligence services. And even the Swiss intelligence service will not get the real stuff from the CIA, for example. They will just say, this guy, and consider him a threat, or maybe a little bit more than that, but they will not get the source and all the credibility of the information and so on. And just knowing how this information is being collected and what interests are involved and how unreliable this is, it's not really reviewable.
No.
Therefore, it is so important to have a narrow definition, and you presuppose some form of threat. Otherwise, it's a vicious circle.
Yes, I fully agree. I have also a follow-up question for Sandra and Françoise. On your slides, Françoise, you had a wording in relation to the exemption for humanitarian activities. What do you think about this wording of humanitarian activities? Is it broad enough? What about other activities that are being conducted by humanitarian organizations? Would that mean that each time a humanitarian organization is conducting other activities, well, this organization might be covered by that law? Does that mean also that you need to prove as a humanitarian organization that you are conducting humanitarian activities? Isn't it too narrow?
I think it's a good question. It's a question that results from years of so-called impossible language. What is defined by convention is the ICRC mandate, the International Committee of the Red Cross. And for a while, exemption were mentioning only, would say, the International Committee of the Red Cross, because states say, this is defined. We know what it is. although they have written common Article 3, it has been written by states, and they say ICRC and other impartial humanitarian organizations, and they finance and they fund impartial humanitarian organizations everywhere, because the ICRC is not able to cover everything on earth. So, so as lawyers, we always have this issue of definition. Sometimes it's good not to have definition for good purpose, and sometimes it's good to have a strict one. And I fully support what is said by Nils about the fact that we pretend that the judge will do the control where we know that there is no control possible. What is said about the judicial review is, for me, the same for targeting under IHL, because targeting is done now through intelligence only, and there's no element to review a target. This is why they call it a mistake. So I think lawyers and practitioners have to be very strict about that. And I remember at the time of the war on terror, lawyers from the Pentagon were the most strict people, saying, we are opening ways that we cannot control. And it was civilians, you know, people, and of course the Ministry of Justice, that were playing full with the law. As a democracy, our only strength is the rule of law. And we are completely destroying for our own society, and we are completely destroying the ability to deliver humanitarian assistance in conflict. So all what was given after Second World War, we are giving it away, and people are really not only short-sighted because they are intelligent, but for me, they are lazy. When I see judges opening the criminal code that way, just to make sure that they will be able to sentence someone, this is really laziness, and I would say, professional laziness and ego. I mean, judges will not solve the problem of terrorism. Impunity is not the issue. Like we've seen that war is not the issue. The war on terrorism has spread terrorism. The impunity against terrorism will kill the rule of law and democracy. I think it's important that people that have the knowledge and the experience are clear about it. If they still want to go on that track, it has to be, but this will be an enlightened consent by our democracy. And today, the consent of the people is not at all an enlightened consent. So this is something I want to make straight, because we are speaking among, you know, intelligent, educated people, having experience, and also spreading the, you know, last voice. When I say that I'm happy about this exemption, it's because it is our last voice before disappearing as humanitarian organization from operational country at war. Is it what we want, when multilateralism, UN, and diplomacy is not able to manage conflict, not even to bring peace? So I think the choices has to be made very clear, so that people that have the power are really in position to decide and to take the responsibility for that decision for today and the future, because tomorrow will not be simple. And that was it. Your question was about something else. No, about the definition. Yeah, for years we have, you know, evolved around the definition of what is a humanitarian organization. So now we have language that have been very hard to get at UN resolution level. We got language at UN level that is even somehow better than the one that is strictly in the Geneva Convention. If you take out the Article 3, you have the issue of the consent of states that have been abused largely by Syria to refuse humanitarian access in territory not controlled. So the language today that is pushed is quite interesting, because it covers services brought by humanitarian organization, you know, compatible with Article 3. So it gives back to the humanitarian organization the responsibility to define themselves and to defend themselves as impartial, humanitarian, and neutral and independent. Otherwise, if we work under the protection of our countries of origin, we are not independent, we are not neutral, because no one is neutral today in the world. So I think we can have more. We have got, I think, a very good language, and it's, you know, lawyers know how to fight with existing language. What we cannot do is create law when there is a silence.
Mhm.
And will, you know, the intention to make sure that everyone is covered is dangerous, because each organization has today to define itself as either a kind of development organization in support of the state diplomacy, or as an independent, let's say, dunantist organization. But I think NGOs has been used also as a kind of soft power by states for a while. Now NGOs, if they don't want to be soft target, have to take back and keep their independence.
All right. Thank you very much. Sandra, do you want to follow up on this?
No, I agree with that. You know, it's, I mean, the Swiss law actually speaks about services, now it doesn't speak about activities, and it speaks about humanitarian services. So I think in a way what they did was referring back to both the humanitarian aim of either the service of the activity, and I think that actually allows you to bring in a lot of things, you know, now the resource is up to you to actually show, you know, what's the humanitarian aim of what you're doing.
Mm.
And I think what is quite interesting, if you look at the new ICRC commentary to the common Article 3, you know, they have an entire, they have many paragraphs about what does humanitarian actually mean, which is interesting because it's, we have actually already defined that, no? And if you look at it, I think since it speaks about, you know, it's about preservation of life and human dignity. So I think it allows you to bring in a whole range of activity, but then it's also up to us to actually define and say, you know, why is this apart from, and I think the other aspect is this of humanitarian organizations, but also we shouldn't forget, you know, this is also about safeguarding principle humanitarian action. I think also humanitarian actors also have an interest in being a principal humanitarian actors, and then it's also up to us to lift this and put this into practice. So
excellent, thank you. A follow point by Nils.
Yeah, just if you allow me on the humanitarian exemption, I mean, I just want to draw, as wonderful as this exemption is, draw your attention to the fact that it refers to services in compliance with Article 3 Common, which applies only in armed conflicts. As soon as you're below the threshold of armed conflicts, there is no exemption. And counter-terrorism does not require an armed conflict, unless, so are we now going as humanitarians to push the notion of a war against terror so we can have an exemption? You see the danger of this. So just a word of caution.
Yeah, great point, thank you. So let's open up to questions from the floor. I will take one question from the room, and then I will take one of the chat questions. Tarek.
Well, actually, I want to ask as well about the humanitarian exemption and how, I mean, from the experiences in different countries, do they indicate what the personal scope of the humanitarian services? And I mean here, do they say that only civilians are entitled to this humanitarian assistance? And let's assume it's yes. Operationally, I mean, how would they manage this in areas controlled only by state armed groups designated as terrorists? Because it's impossible to give assistance only to civilians. And the related question here, does this give the basis to the states to refuse this humanitarian exemption or object it and say it's impossible to give it only to civilians, so we just object it? This is my question.
Who would like to try to respond?
Could you just explain a bit the second part of your question?
Well, the second part, if it's not possible to give the humanitarian assistance only to civilians, because the area is controlled by non-state armed groups, does this give the basis to the state of territory, to the parties of armed conflict to say we can't accept this humanitarian access, we can't accept this exception to deliver assistance to this area because we can't make sure that it will be delivered only to civilians. So yeah, I mean, because the personal scope is not clear. I mean, when we say comparing exception, what's the personal scope? Who's going to benefit from this?
Nils?
Maybe if I could just say a few words. First of all,
Yeah.
there is no distinction between terrorists and civilians. It's between combatants and civilians. Most terrorists are civilians. Those who finance terrorism are civilians. It's very important not to fall into this trap that is being set up for 20 years. Terrorism is not necessarily combatant activities. So I think that it's a crime. That's not the same thing. That's the first thing. The second thing is, I mean, we've had this for a long time. Humanitarian aid, there can be some benefit to the military, even the regular army, and you can't prevent that completely. It just can't be confiscated by the government. But humanitarian aid really is not. You can't starve civilians to death because the fighters will benefit a bit from them. And it's not only food; it's medical aid. And they have a right to have medical aid as well. Mm-hmm. I mean, I don't know whether someone needs to compliment, but the most dangerous thing is to say, "Oh, terrorists are not civilians." That's very dangerous.
Yeah, I agree with that. I think it was also on one of François's slides, and this is precisely in a nutshell. That's the conundrum. Now, when you mix these two regimes that actually use very different statuses and legal categorizations, and that's part of the importance of actually having a humanitarian exemption, because so it brings back, at least to some extent, what's the proper legal regime to look at these questions, you know, and provide at least one kind of safeguard to say, you know, well, in an armed conflict, you may refer to people or groups as terrorists, but there's a whole other body of law that actually applies in that provides for specific rights and obligations, regardless of how you qualify that under a terrorism regime. So I think that may be part of the broader positive impact of having such a humanitarian clause in there to say, you know, this is not just about terrorism, but in the context of an armed conflict, you do have a well-established and very ancient regime, which, you know, let's also face it, acts of terrorism in the context of an armed conflict are not a new phenomenon. No? IHL actually addresses these acts as well. So you have a very ancient legal regime that already accommodates that and still provides for this right to offer services. So, and then now we have a new regime that has developed very rapidly during the last 20 years without giving due concern to this other regime.
Great. Françoise?
Yeah, a quick comment. I agree that the issue is really to stick to the logic of each legal regime. Under IHL, you are either civilian or combatant. You cannot be a third category of. So, as was rightly pointed, a terrorist is a criminal qualification. We should wait for a judge for that, not to, I mean, and of course they have human rights to receive assistance as everyone. And the IHL has developed this also category of victim of conflict, making sure that the one that has the power will be able to survive, the others will need assistance. And as MSF, since we work on the medical part of the assistance, we are of course able to control and to make sure and to negotiate and assess who is receiving this medical assistance. And medical assistance can never be under IHL described as a material support, although of course it brings the person maybe back to feet. But even for a soldier, it's not a material support or a loss of neutrality. And for a criminal is allowed to be treated, whatever, and we all only speaking about suspected or alleged. So we are not going to apply legal category to people that have not been defined by criminal system. So this is very important because we tend to group every, you know, bad guys running war that are not respecting the law under the terrorist system, thinking that we cannot negotiate also with them. It is not true. It is not the experience of MSF. We can negotiate with them because they have not all of those groups considered as terrorists may have some interest in the fate of the population. we have a specific problem with, let's say, foreign fighter and some franchise terrorist group who don't care about the civilian population, or who are sent to some places to terrorize the population and organize ethnic cleansing of territories. Okay. All right. So this is a little bit different, but it's not the problem of humanitarian assistance. We know what we do, and those people are rich and powerful, not because they received, you know, humanitarian ration. It's because they're engaged into highly profitable criminal activities.
Thank you, Françoise. I have here a question from Vivian Altweg, which is about the measures of the MPT and whether they can also target children. So her question is, what is your take on the compatibility of these measures, most notably the assigned residence, with the UN Convention on the Rights of the Child? What can be expected in this regard from the CRC in view of the next cycle of state reporting? I think it's a very important question. Thank you for that question, because indeed assigned residence can be imposed on people who are 15 years old. So you imagine a teenager, wanting to look at beheadings from ISIS on the web, having maybe a cousin, having committed crimes which had a connotation of jihadism. So this person would be under control orders, having the prohibition from meeting the cousin, etc. If this individual is not following that order, we could have an imposition of assigned residence. So this is the reality around the MPT. Someone like that, a teenager like that, might be covered. So would that be consonant with the CRC? Ilya, what do you think?
So yeah, I think there are many, many other questions when it comes to the MPT. We only had the time to touch upon a few of them, and definitely the question of the applicability of the law to minors from 12 years old, and the assigned residence can apply to people, if I remember correctly, from 15 years old.
That's right.
I would still circle back to my argument from before. The Convention on the Rights of the Child doesn't deal with deprivation of liberty as such. So as long as the convention doesn't apply with other instruments that do specifically deal with deprivation of liberty, it is hard to imagine how it would nonetheless be in compliance with the Convention on the Rights of the Child. And I guess in individual cases, the questions of necessity and proportionality, the threshold will be much, much, much higher when it comes to, let's say, a person of 15 years old. Mm-hmm. And when it comes to what can be expected from the committee, I guess that's not a question we can answer authoritatively, but I guess that would be up for NGOs to pick it up and present it to the committee, mm-hmm. Because committees work kind of in response to the material that they presented. So I guess that's that. But I have to acknowledge that especially the question of children has attracted a lot of attention in Switzerland. There were like many op-eds specifically dedicated to that question, because indeed this is something beyond imagination, how a 15 years old child can be put under house arrest for being
9 months.
A potential terrorist.
Nils.
I just want to say that at least in practice, in jurisprudence, we have clarity that deprivation of liberty for minors should be used only as a last resort. Mm-hmm. Obviously, you can't prohibit it completely. Even in armed conflict, you have child soldiers. You will have to, keep them somewhere safe for a while until you can actually deal with their situation. And so there's a reality question here. But still, what we see throughout the world, also in the context of migration, not only terrorist suspects, that this is systematically being ignored now. Mm-hmm. And you have millions of children basically in detention, in preventative detention for immigration issues. We're not even talking terrorism. So I think you have to be aware that and also a lot of children have parents. Actually, all children have parents, and they may be affected. So you put them away, you put restrictions on them. It also affects children. I mean, I just think this kind of systemic view is important.
Sorry, can I maybe just...
Sure, Roberta, thank you.
It's very interesting to hear about this. And the question that I have is, right, I think we all agree that these provisions pose some problems under international law, but what are the alternatives? Because we all know that we can't take the Swiss situation as a standard. I mean, if we look at other situations like Somalia, the Middle East, other conflicts, we have had people underage, minors, who have been involved if I think about situation in some armed conflicts with the recruitment of child soldiers, it has posed a big dilemma what to do with these children, whether they can be prosecuted because they actually committed war crimes or whether they are victims. And with terrorism, I think that it goes hand by hand. We have teenagers who actually might not be aware of the violent content of some images. They disseminate them. We've noticed this also with sexual crimes, where we increasingly hear about sexting and people who are the object of sexual abuse, and with these videos circulating. So there is a need to intervene to stop this. But the question is, how do you go about content or activities that have a higher threshold that might lead to some involved in terrorism? And in this regard, something we have not addressed this evening is what corollary complementary measures should be adopted to counter terrorism apart from criminal law. Like, for instance, try to de-radicalize people, try to educate children in school, to raise awareness. So maybe some of these measures have been adopted because we lack the complementary measures that would allow us to renounce to these really very strict and severe repressive measures. So I'm not sure what the panel thinks about this.
Sandra, what's your take?
Normally when you look at children, I think it's always the best interest of the child, which should be the prevailing consideration. And then yes, maybe it's because we lack accompanying measures, but then I would also say that's in itself not a good reason to have this. But what I did want to flag is several of you now have mentioned, the question of child soldiers. So I think on the one hand, that's also a partial response to Roberta's question, that there is actually existing experience and expertise on how to deal with children who have been involved or exposed to, very traumatic and violent crimes. And the second aspect of this is, and we have said, there are linkages between our two bodies of law, is where we see how CQ law displaces some established notions. So we have spoken about IHL, but here you can also see how it displaces established child protection. And that not only in peace times, but we have also seen this in recent years in relation to children affected by armed conflict. The precisely this traditional vision where we said, yes, there's a dilemma, but we all agree that a child soldier is primarily a victim. And then you can have questions of agency and what's their responsibility, but primarily a victim. While nowadays we see the IHL protections given to children in general, including children associated with designated terrorist group, they're also being displaced by a superseding counter-terrorism regime where you look at them as, potential future terrorist threats, and you deal with them primarily as such.
Yes, and this makes me think about the question of the effectiveness of these type of measures, because I'm wondering whether it's really useful to label some individuals, including potentially teenagers, as potential terrorists. The alleged aim is to prevent radicalization. I'm wondering whether psychologists have been consulted. Does it really prevent radicalization to label an individual and including teenagers as potential terrorists, or taking controlled measures against them? So I'm not 100% convinced that these are the most effective measures to prevent radicalization. So sorry, I abused my role as a moderator, but I wanted also to bring that issue of effectiveness on the table. Do we have a question here in the room? Yes?
Thank you very much for the very interesting panel. I was just wondering if the second law does introduce any sort of integration measures, like for people that are labeled as terrorists. I don't know, because I do understand that there's a tendency to have this sort of integration measures of I don't know, having classes for the so-called terrorists to learn the language of the host country, or I don't know, to be less radical in their religious beliefs, like whether this Swiss bill has anything like that, and if it doesn't, what is the general recommendations of the panel with regards to this sort of interrogation measures?
Who wants to?
The law itself, of course, doesn't say anything about sort of quote-unquote de-radicalization measures. What is clear from the background document to the bill and from the discussions in Parliament is that the idea would be that the law will be applied against individuals when the sort of de-radicalization measures are no longer effective. So it's supposed to be kind of a supplementary mechanism against those that the state has failed to establish kind of meaningful contact with. I guess one of the measures, and that is the obligation to come to interviews. I guess that is kind of a part of the wider program. I guess as it goes, it depends on a canton, and so this is the role of the cantons, as far as I understand. They will be the ones devising the plans to, again, quote unquote, de-radicalize those individuals. So that's that. But again, it's not quite clear how exactly would it work, and if it all comes down to sort of like a prosecutorial discretion, would it be the police who would be deciding when the person is no longer kind of able of being de-radicalized? So this is unclear. I guess we'll see how it works in the following weeks when it comes to the initial control orders. Assigned residence, I guess, would take a bit of time because they have to violate the initial one first.
Yes, Nils.
I also just want to raise a point here that this is obviously these types of measures of rehabilitating or re-educating potential terrorists is a double-edged sword. I mean, you just have to look to China, where these are concentration camps that they have, where I mean, thousands of people are being re-educated. They're called vocational training centers. I mean, I don't want to compare to other centers in history where it said that work, leads to liberty. I mean, it honestly frightens me to see how authoritarian regimes use this notion of, oh, we'll have to make peaceful citizens out of these people, and therefore, I mean, we're not there yet here, but this will come as a challenge. And therefore, we have to be vigilant and insist on the only thing we have to create a system that prevents abuse of power, and that is the separation of power and effective oversight by the judiciary, of an independent judiciary. So they need access to information. And this ties into the whole secret service regime that has been created globally, which operates secretly. It's all off the record. We have secret courts in the US, in other countries. It becomes normal that we don't have access to information. We have Freedom of Information Acts and can receive thousands of pages. I first received thousands of pages in response to a request from a state authority. Of these 5,000 pages, 2,000 were blacked. How is this freedom of information? We don't have access to the information, so we don't know what people are doing, and we're all human beings. We don't have to be bad by nature to abuse our power. If there's no oversight, we will start expanding our authority. It's like this, it's the same on the highway, the parking fees. If there's no oversight, people will not pay parking fees, they will not respect the speed limits. What makes us think intelligence services are different? They enjoy that, not as a matter of pleasure, but they have these privileges and they will use them to the fullest. And now we're creating a regime where the federal police on its own can make these determinations based on information they have no idea where it comes from. And no one can actually check up on it. And then we decide we have to rehabilitate people who pose no criminal threat because our definition doesn't require that. And if they protest in violence of these rules, all of a sudden they become criminals. So I think we're going in a very, very dangerous direction. We have to think about the sanity of our system. And obviously, what's the answer? It's difficult. How do we respond to the terrorist threat, which is a real threat? I started out with this acknowledgement. I think we also have to think about the causes of terrorism. If we have an inherently violent economic and political system, it will produce violence. And in the end, we'll have to deal with it also at the end of terrorism. But we have a part in how we structure our economies and our political power systems in order to prevent these things. I'll stop here.
Thank you very much. I think these will be the last words. I had some more questions on the chat, but I realized that we spoke quite a lot. and that you might want to eat as well. So I thank you very much, our panelists, for this very rich conversation. I think it shows all the dilemmas when states, even law-abiding states like Switzerland, try to counter terrorism, that this might incidentally have impacts on humanitarian action and on human rights. Thank you very much for your attention, and we will follow that closely. Thank you. Bye.
Thank you.
Thank you very much.